Audio check. Well, the inquiry is resumed then, ladies and gentlemen. So the next bit on the agenda is to go through the list of draft conditions. Can I just check what status these have? Are they fully agreed between the parties, or are there going to be some areas where you've got disagreements?
No, I think we are agreed on the draft that you should have in front of you.
Okay, well that's helpful. I mean, what I would normally do is ask one side or the other, usually the council, to just take me through briefly each of the suggested conditions so that I understand why you consider them to be necessary and what they seek to achieve. And if there is any disagreement, then I'll obviously hear from the other side. But it sounds though they're all agreed, so it might be a bit of a one-man show. But if you'd like to take me through them, and obviously if the appellant has got comments on any of them, then please just shout out.
Okay. Thank you. Well, in terms of the first condition, this one would probably normally be expiry of 3 years from the date of the permission, so this is a commencement date. That's been brought forward to before the expiry of 2 years, which I think was at the suggestion of the appellant. Okay. And I think we're happy to agree that on the basis that that should bring the development forward, if anything. Okay. The second condition is to ensure that there is effectively no doubt as to what scheme is actually being implemented, and without prejudice to the sort of further discussions that will take place as regards Y12, 13 and 14. Yep. Those are the February 2022 ones are recognised within this list.
Yep. Okay.
In terms of condition 3, this condition is proposed in recognition of the value of the orchard or the former orchard in terms of biodiversity characteristics, and it seeks to ensure that it's protected during the construction phase from plant materials or other sort of forms of storage taking place on that, and makes clear that the orchard will thereafter be retained as open space that prioritises biodiversity objectives in accordance with a management plan which will need to be submitted.
Yes, now can I just be clear on the the track changes? I can see this was one that I just made some minor comments on, and mine are there in blue. I can see that, certainly in the version that I've got. The I don't know what colour we call it, purple, where it says that prioritises biodiversity objectives. That wording was in the previous version that I'd seen. Why is it highlighted, or why is it shown in that form?
Well, I think ordinarily open space, I think, probably would be regarded as being something that's there for probably primarily recreational and leisure purposes. And I think in this particular instance, we wanted to make it clear that its biodiversity value should largely influence the way in which that open space is used and managed in future.
Yes, sorry, I appreciate that. I perhaps didn't make my point clear. I'm just trying to ensure that I'm following this latest version of the conditions alongside the previous version that I had. So I'm looking for changes between the two, and the bits in blue seem to be additional bits that were as a result of my comments, but the purpley bit was already in there, so I just wondered why it was shown in a purple colour. Just
briefly looking at Mr. Quartermain to see if he can recall exactly what happened on that one.
I don't know who's added that in. It wasn't put in by our team, I don't think.
Well, as I say, it was there in what I'm seeing as my earlier draft version. I'm not quite sure when this came through. It was sent through obviously prior to the inquiry opening, and I've got those words in this one.
The version that the live version here shows, unfortunately, Mr. Wilmot, that's inserted by yourself.
It does show my changes. You're absolutely correct on that, but they were from the 17th of February.
Okay, so really I shouldn't be reading anything into that colour there, because it's no change from the previous version that I had. Okay, right.
Then proceeding to condition 4, this one effectively has to be read to a degree in connection with the way that the Section 106 commitments are also sort of providing for early establishment of habitats. There's a highlighted change in there which we agreed at lunchtime, which really just recognises the fact that those works may go wider than just planting hedgerows or the erection of the bat roost. It may also include things like ecological seed mixes being sort of applied to the ground and so on. But essentially this condition effectively precludes work such as site clearance, preparatory work, or any development taking place until there's a plan in place for protection of the orchard. But it excludes from that things that are specifically there to actually provide the beneficial effects of replacement hedgerows, erection of a bat roost, or seeding.
Yep. Okay, so in terms of changes to the condition as the version that I had previously, obviously you've changed the introduction, as it were, to it by adding that additional phrase.
Yeah.
What's this red bit? Just let me look at that again. So you've just changed retained trees to be retained from retained tree. I see. Yes. Yeah. Okay.
In terms of condition number 5, this again says that other than the establishment of habitats, again through this same wording, including the planting of replacement hedgerows and the erection of bat roosts, no development shall commence until there's a phasing plan showing the location, design and timing of those tree and hedge protection measures. So this is effectively, I think, trying to sort of ensure that there is a mechanism to agree the point at which those elements will be undertaken. I think that the red text, which has got strike through on it, we've accepted there's no particular need for that, because effectively the timings will be dictated by the phasing plan that is actually to be agreed.
Yes, yeah, I see that. Yep, okay, thank you.
Okay. Condition 6 again has the same sort of preamble to it, but is essentially is saying that prior to development taking place, there's got to be a construction environment management plan and method statement in place, which will relate variously to traffic and transport, construction, and sort of logistical sort of measures, but any of which could equally have environmental implications as well.
Okay. Yep.
In condition 7, again the same sort of preamble to it, but we have agreed that there should be a biodiversity protection plan that is put in place, which will again detail measures to avoid any harm arising to ecological features and trees.
So, sorry, can I just be clear? This is a new condition, isn't it, compared to what I saw previously?
That's correct. Yes, it is.
Understood. Yeah. Okay. So, sorry. Take me through that again. I was just getting my bearings.
Okay. Yeah. It's to ensure that no development other than the establishment of the sort of ecological sort of works, no development should take place until a biodiversity protection plan has been submitted to and approved by the council, which will include measures to avoid harm to ecological features and trees. And my understanding would be that could even apply to some of the new planting that actually takes place, not just existing vegetation.
Yep.
This new condition 7 extracts previously what was part M of condition 6, and that was moved into its new condition on the advice of Mr. Clarkson, the ecologist, on the basis that the CEMP is normally prepared by the contractor, whereas the biodiversity plan would have an ecologist input. And separating them out into 2 different conditions with 2 different plans is just easier to coordinate.
So that's the deletion of M, is
That's
it?
right.
Yeah, got it. Thank you. Yeah. Okay, thank you.
Okay. There's a renumbered condition 7, which now becomes condition 8.
Yes.
Which just requires details of the finished floor and ridge height levels. Again, it's fairly standard practice as far as we're concerned, and in particular where there are adjacent dwellings, we find that's essential really to have a clear understanding of what those ridge heights and levels would be.
Yep. Okay.
Condition, or renumbered condition 9, requires agreement effectively on the materials for the sort of masonry and roofing materials, colours of any render and so on, but effectively we're agreed that it's not necessary to say that there can't be a start on site. We've tried to leave it to a sort of mutually acceptable sort of stage in the development. And I think that the red text has been deleted because I think Catherine Bentham had indicated that this is probably only likely to be a single phase development given the scale of it. It's not one where we've got potentially hundreds of dwellings where it might be done in different phases.
Okay. Just bear with me. Did you refer to phasing earlier on one of the other conditions?
I think there will have been a reference to phasing, but that was, I think, in relation to I think it was the planting and mitigation works, if my memory serves me correctly.
Yeah, condition 5, just
Yeah,
spotted there, a phasing plan. So it's phasing in terms of planting as
Yes.
opposed to development of
Yes.
the housing. Okay, thank you.
The renumbered condition 10 requires cycle storage for each dwelling. As an authority, we're very keen to pursue sort of active travel and facilitating that ability to store bicycles safely and in the dry in each plot, I think, is quite important to that.
Okay.
Condition 11 as renumbered again allows for the ecological works to sort of proceed, but does require a landscape ecological management plan to be submitted for approval. That contains various measures that will assist with the ongoing management and maintenance of the open space, whether that be managed by the council or its nominee as set out in the Section 106 agreement, or ultimately by a management company, which is, I think, effectively a sort of fallback position within the legal agreement.
Okay.
Condition 12 sets out, again, that no development shall commence until the landscape phasing planting plan has been submitted to and approved, and that is there to deliver the landscape master plan referred to in condition 13, which I think is the following condition, and relates to the whole site. So it will include details and phasing of items such as the pond construction, the landscape planting and habitat creation measures as identified within the Advanced Habitat Creation Phasing Plan. Oops, sorry. Which is, I think, in accordance or as provided in Mr. Clarkson's proof of evidence in Appendix 4.
Okay.
So that LPPP will establish elements that will be delivered in advance of construction work commencing on site. And again, there is provision for that. This cross refers to the legal agreement.
Okay. Yep.
I think as a consequence of those changes, the following paragraph is deleted in its entirety.
So that was condition 11, was it? Sorry, yeah, so it was 11. So I'm trying to see the bit that's deleted in the earlier. Did that feature previously? Oh yes, I think I've got it there. Yeah, okay. I think I can now see which bit's gone, so yes, okay, thank you.
Condition 13 then refers to the submitted landscape plantings plan as set out in drawings Y12 and 13 and the planting schedule Y14, but says that no development shall commence until further details of the landscaping scheme has been submitted. That will require details of the size, species and spacing of trees and plants. I think that's in part in recognition of the fact that although the planting schedule is, I think, quite comprehensive in a lot of respects, particularly in terms of the size and species of stock that's to go in, what we did note, I think, on those versions of Y12, 13 and 14 was that although I think there was reference in Mr. Clarkson's proof and the shadow HRA, for example, to planting alongside the access road, there were a number of those trees that were never detailed as to the sort of position of those actually in those landscaping plans.
Okay. Yep.
Conditions 14 and 15, again, we're agreed on those. Those are, I think, pretty standard wording relating to the implementation of the details of the landscaping, which will apply, relate to the initial phase of planting within the orchard, and then 15 covers the necessity to potentially replace those trees for a period of up to 10 years.
Okay. Yep.
16 relates to there being no culverting of any watercourses on the site without the agreement in writing of the local planning authority, and that's just again part of the drainage and surface water proposals.
Yeah, I think that's that's one that I felt I didn't understand what was meant by the likes of the reference to access points. So you've resolved that by simply deleting it. Okay,
Yeah. Yes. 17 relates to works for surface water drainage works. So no development is to commence until surface water drainage works have been implemented in accordance with details that will need to be submitted to and approved in writing by the council. And the condition then sets out in detail what the expectation is of the details to be submitted.
Yep.
Condition 18 requires effectively, before development taking place, to have details of the implementation, maintenance and future management of the approved sustainable drainage scheme. Again, that's something which we regard as absolutely essential. Even with any sustainable drainage scheme, it's going to require some level of maintenance at future if it's to remain effective. And again, we set out what our expectations are in terms of the level of detail that will encompass.
Yep. Okay.
Condition 19 is applicable to the road drainage in the existing highway along the frontage of the site. That's to ensure a functional and effective drainage system for that, and for site access to the nearest reen.
Yep.
20 is a fairly widely used condition which protects the interests of the internal drainage board, in particular to be able to obtain access to the main watercourse in the area for maintenance purposes, and that is the Stowe Reen, which I'm sure by now you'll be very familiar with.
Yep.
Condition 21 relates to the generation of energy in accordance with our policies CS1 and CS2. So effectively, it's clearly advantageous, I think, for any developer and in environmental terms to ensure that the basic fabric of each dwelling is such that it minimises the energy usage, but this then seeks to secure a percentage of that predicted energy requirement actually being generated on site.
Yeah. Yeah, thank you.
Condition 22 requires the construction and or provision for storage and collection of waste on site, particularly in the nature of the roads, and I think what we tend to find in terms of parking, it's essential to have a sort of clear pick-up areas. There are limitations on how far operatives are required to actually collect waste, and so again this is to provide convenient and safe locations for those.
Yep. Okay.
23 requires the provision of hydrants to serve the development to a standard recommended by the Avon Fire Service. So that's the provision. This is, I'm not sure mirrored is quite the right word, but it's accompanied by a provision within the legal agreement for the covering the cost of maintenance of that for a period of 5 years, which otherwise falls on the Fire and Rescue Service.
Okay.
24 looks to secure bird nesting and bat roosting strategy, and for those to be incorporated. And again, those can be done, I think, probably potentially by a variety of means, but probably more increasingly frequently these days being met, I think, by things like bird boxes or bird or bat bricks incorporated into the fabric of buildings.
Okay. Yep.
25 is a safety one, again a fairly standardised one. We've agreed on some changes to the wording here, which I think focuses a concentration really on the question of there being no obstruction to visibility at or above a height of 0.6 metres above the near side carriageway level, and that would need to be maintained as such.
Yep.
26 reflects the fact that although there was a travel plan submitted with the original application, that travel plan was dated 2015.
Right.
And I think our anticipation is that there would have been significant changes, particularly in people's habits, expectations and working practices since then that ought to be reflected. 27, I believe, was a subject, at least at some point in evidence of discussion about fencing within the orchard area. I think we felt that if we were looking to try and maintain the biodiversity value, then that would be very difficult to do without some form of control over access. And I think we merely want to agree that what that sort of fencing should be and how widespread across the orchard it should be.
Okay, yeah.
28.
Sorry, just before you go there, if it's 26, I think my old 26 it is, isn't it? So that was just one where I think I'd queried this management plan. Has that been addressed? That's actually gone. That's in one of the struck out bits,
it's in the
isn't
next
it?
condition. We've moved the management plan to the next condition.
Okay, I'll keep quiet. Yeah.
Okay, so 28 covers that orchard management plan, effectively, which will be composed of the LEMP required by condition 11, the LPPP required by condition 12, and the fencing plan required by condition 27.
Okay, yeah.
And then the final condition is for submission of details of the proposed play area.
Yep. Yep. Okay, thank you. As you went through that, I was just seeing whether those words, arboricultural method statement, would jump out at me, because that's one of the things I asked Mrs. Ventham, and I didn't spot it there. Is it included in any of the other more
in condition 4,
general? Condition 4.
in condition 4, towards the bottom of condition 4, it requires the arboricultural method statement to be submitted and agreed in writing by the LPA.
Sorry, where am I looking in there? So new condition 4.
It's the line above the blue amendment saying
yes,
submitted
got
to
it.
So it requires a tree protection plan and the ARB statement.
Yep, that's fine, thank you. Yeah. Okay, well, thank you for that. There was nothing that I could recall, excuse me, having referred to relating to any of the conditions that hasn't been covered there. Perhaps a superfluous question, because obviously you've agreed these between you, but is there anything else that's occurred to either side as we've gone through the conditions that ought to be included there? No. Okay, so I don't know if that, oh, excuse me. I don't know if this latest version has yet found its way to the Inspectorate's case officer, but if not, can it be emailed through, please? Thank you. And I think we can then move on to consider the Section 106 agreement. And again, an agreement, so how am I to take it here that there is no dispute? I know Mr. Leader put in a note earlier on with some concerns that the Council had got about a couple of points. I mean, have they been addressed, and have we moved on from that? Okay, so just bear with me. Let me put the conditions to one side. 106. I didn't have much time to look through this in any sort of detail, but one thing that I did pick out just on the covering note, at least I think it was the covering note. Yes, when we got to public open space, it referred to that as being the third schedule, and so the from 15, paragraph 15 onwards, and the heading above that, public open space, third schedule. When I quickly looked at the agreement. That appeared to be the second schedule for, and so there's a few other references in, where are we? First line of 15 says Schedule 3. Second line of paragraph 17 says the third schedule. So if I'm following it correctly, that those references to the third schedule there actually look to be the second schedule in the agreement itself.
That's correct, sir, yes.
That's correct, yeah, okay. Right, well, really, same exercise as before. I just want to be taken through in an overview form what the agreement seeks to achieve, and highlight any particular matters that I need to be aware of in it, please.
So yes, are you content to go through the summary rather than the
Yeah, I suppose that would be,
agreement?
that's fine. Happy to do that.
It's taken largely from the agreement, but it
Yep.
strips out some of the legalese, so maybe a bit quicker.
Okay.
So I should point out it says draft at the top.
Yeah.
There has been negotiation in between this draft being produced and now, which we'll come on to with the transport contribution, the education transport contribution, which I believe now is agreed, which means that the whole document is agreed.
Okay.
And so following today, I'm happy to circulate another version of this with draft removed and red type taken off it.
Yeah.
So yes, a summary of the obligations. The first introduction outlines the parties primarily to the agreement, which will be the council, the present landowners, chargees, and the developer, Persimmon. We jump ahead to the first schedule, which is the affordable housing provision, and as you will see, it's set at 30% of the dwellings to be provided as affordable housing. The split for social rented as against shared ownership and type are set out there in the table.
Yep.
That table's taken directly from the agreement, and so is, I understand, agreed with the council.
Okay.
At paragraph 4, there's the requirement for the affordable housing plan. This provision is a standard one of the councils, and in this case probably will not contain a great deal because the details are primarily now agreed. The affordable housing plan would normally deal with quantity, location and tenure, but as we've just discussed, that's primarily agreed now. So paragraph 5 requires the affordable housing to be provided in clusters, not exceeding 6 or 12, where it's supported. I'm not sure there is any supported here. Paragraph 6 deals with the use of the affordable housing, which is, again, a standard provision to require that it's used as such. Paragraph 7, restrictions such that the restrictions in the agreement shouldn't apply to certain people, such as protected purchasers, mortgagees, their chargees, and successors in title. Yeah. Again, a standard provision. 8 and 9 both deal with delivery, so requiring 25% of the affordable housing before 25% of the open market, and similarly 100% of the affordable housing before 85%. Paragraph 10 deals with transfers to the HARP, which is the affordable housing provider, and certain requirements for such transfers. Then paragraph 11 deals with requirements that the HARP will be subject to, including nominations policy, a requirement for target rents in relation to social rented units, and restriction on service charge. So again, all very normal. Paragraph 12 deals with disposal of the shared equity, shared ownership units and specific provisions related to those disposals. And paragraph 13, where it releases effectively a shared ownership unit where the tenant staircases to 100%. Paragraph 14 is then the standard mortgagee exemption clause in the event that the Harps chargee needs to sell the units for some reason. Then on to public open space. Paragraph 15 is dealing with the defining or the definition of the open space in general, what it's required to include, such as the LLAP and its requirements. 16 deals with the open space works, a requirement for maintenance of the biodiversity elements not less than 15 years, and phasing of those works. Paragraph 17 requires the supervision fee, so that's the council's fees for going out and checking the works as they're carried out. Paragraph 18, the open space works and what they are required to include, and there is a list there including detailed specification. This drills down further than the outline of the definition that's within the 106. The main point to note here is the discussion that has been had already in relation to the early delivery of the ecological mitigation works, particularly for the bats. And there is a definition now within the 106 that early can mean no sooner than the planting season prior to the commencement of development. So it's just to limit that so that we understand what that can mean. Then in terms of delivery of the open space works must be completed before the occupation of no more than 50% of the dwellings. And then paragraph 20 relates to the transfer of the open space land. In this case, the council have indicated that they would want control of that such that it be transferred, offered to them or their nominee first, and only if that's not accepted would it go to a management company. Okay. So then if the paragraph 21, if the land is transferred to the council, then it goes with a maintenance contribution as you would normally expect. Paragraph 22 is primarily to ensure that the developer doesn't use the open space as a construction or materials compound. And 23 deals with the onward use of the open space, which is to be in perpetuity as public open space. Excuse me. Paragraph 24 and onwards is the second third schedule, so. And this deals with the payment of contributions. I think these are all fairly standard. You heard in relation to conditions that a fire hydrant contribution is required, and obviously the 106 provides the mechanism for the actual payment of that.
Yep.
Then there is a REEN maintenance contribution of £19,400. That is to ameliorate drainage capacity on the Stowe Reen. The secondary education transport contribution, that, as I said, so is in red, but I believe that is now agreed. It has been the result of, or the subject of, some negotiation right up to this point. Mm-hmm. Then the sports pitches relocation contribution, again a figure agreed with the council. I think it speaks for itself. And then sustainable travel contribution of £120 per dwelling, which is for the provision of travel vouchers, information pack, tickets and cycle vouchers.
Yep.
Then the TRO contribution of £3,100, which is in relation to primarily paint on the road to prevent parking, either on or in the vicinity of the development. And then paragraph 25 is in relation to interest on late payments, and 26, indexation of those payments up to the date when they are paid. Then generals, I'm not sure how much you want me to go into those, but deals with such things as VAT, interpretation, standard legal interpretation, and the position of the landowners as a charity.
Yeah.
Nothing of any great movement or moment in there, sir.
No? Okay. Okay, thank you. So the only sort of point that needed some clarification was that transport contribution that you say has now been agreed with the council.
I understand it has been, sir. I was awaiting an email to confirm that in black and white, but my phone hasn't been receiving messages since 12 o'clock, so I'm assuming that isn't a problem.
Okay, well, on the assumption that that is agreed, as you said a moment ago, you'll be able to reproduce a further version of this without draft, as it were, and then it can be treated as, well, virtually the final document, I suppose. There, I haven't looked through here, but I realise that now there are some plans appended to this, which I know are referred to.
They are.
In the schedule, sorry, in the accompanying note, so I'll look through those as well, but I don't need to do that right now. Is there anything else on the section 106 that we need to discuss? No? No? Okay, so in that case, I think we've more or less done all we can at the minute. Let me move on first of all to what will happen tomorrow for the site visit, and then we'll talk about when we resume. So, I've got the site visit at 10 o'clock, and I've got the itinerary that had been sent. The first point on it says site frontage along Moor Road, including junction with Kenmore Road. On the assumption we're going to work through this in more or less this order, is that the proposed meeting place, and is there a convenient parking place that I should know, or is it a case of find somewhere to park and then meet there? Yes.
I suspect it may be difficult down Kenmore Road, because quite often rail station users use it to avoid parking fees. That may be less of a concern as it's half term this week. I can't guarantee it. I think the next best alternative, to be honest, is a little way away from there, would probably be the rugby club car park.
Okay.
I do have permission for us to actually go into the rugby club, should you wish to view the appeal site from there.
Yes.
There is parking at the front of that.
Okay, so from what you're saying, I'm going to try and find where I can best park. And if it happens to be the rugby club, am I allowed to park in the rugby club? Is that what you're saying? Or we have access to the rugby club?
I believe so, but I certainly have a contact at the rugby club, the chairman, who I can confirm tonight whether that's feasible. I don't know how, or I can try and confirm that this afternoon, and relay that message to all parties.
Yes, if you let the inspectorate's case, I'll try and park closer to point one on the schedule than the rugby club, but I just wonder whether there was any agreed area for parking. If there isn't, if it's a case of just find a convenient and safe place, then I will do that. Okay.
Yeah.
So, next question, who am I going to be waiting for at the site visit? Who's going to be there for the council?
It will be myself.
Yourself? Just yourself?
Yeah.
Yep, okay.
Well, possibly Kate Long.
Yes, I thought I got two names, Kate Long and Roger Wilmot. Yes, yeah, okay. And from the appellant?
Mr. Clarkson.
Yeah. Okay. Now, were any of the interested persons contacted, and did they indicate that they would like to also attend?
We passed the message on via the local ward member and parish council, but not had any indication that you're expecting any. So.
No one came back to you. Okay, so I'm not expecting anyone. Obviously, if someone does turn up, well, we'll see what happens. But as long as I know I'm not expecting anyone.
Should say, I think it's possible that somebody from the rugby club may be present, just on the basis that, you know, we're obviously potentially visiting their land.
If we're on their land, yes, of course. Yeah.
I did also secure agreement from the land agent for the former orchard area, and I understand that the tenant also is expecting us if we wish to go on to the land.
Yes, I mean, I would certainly hope to more or less walk the boundary of the orchard area, and we'll see what's necessary on the northern field itself. But I'll be able to view that possibly from the rugby club, but also have access presumably to both fields. Yes. Okay.
Sorry, just on that, just to flag, there is access that's been arranged, but also because there are horses on the field, it's quite muddy, so
yes,
suitable footwear is advised.
Yeah. Oh.
Yes.
Well, I was going to check where we meet. So if we meet at the site proposed entrance virtually, site 1. I know who's going to meet there. I know the time. I was going to say, has anyone seen a weather forecast for tomorrow? I mean, obviously, dress for inclement weather, I think I can say. And footwear, I was going to assume something along the lines of walking boots as opposed to Wellingtons, but one of the two seemed appropriate to me.
It's not supposed to rain tomorrow.
Not supposed to rain?
No,
Okay, no rain.
Probably similar, I think, similar to today.
Okay, but appropriate footwear and appropriate clothing. I don't think there's anything else then I need to say about the site visit, so that seems all okay, thank you. So, when I adjourn in a moment, it will be to set a resumption, or rather I'll set a resumption time and date. Now, I had floated April 4th, 5th and 6th simply because they were my first available. I didn't canvass the parties particularly strongly at that time to find out if it was also convenient for yourselves. Are you? Is that okay, or was there any different time
yes,
preferable?
It's absolutely fine for me. So I think it's already gone in my diary. I'm just double checking, but yes, fine.
And Mr. Leader, yes, and this room venue we're okay as well, are we? Yeah. Okay. Nods. So I think we said Monday afternoon, Tuesday, and Wednesday. Yes. So in theory, we've got, well, not in theory, in practice, we've got to get through the ecology witnesses from each side, possibly recalling planning witnesses. I don't know whether there's going to be any need to revisit anything on the conditions session, but I think what I'm saying is, although we know the obvious thing that we're coming back for to deal with ecology, there could be these peripherals, there could be the planning bits as well. So I think it's wisest to have the Monday afternoon as well as the Tuesday. So I'm envisaging Monday afternoon, then so we deal with ecology, then carry over to Tuesday, possibly have planning, and then have closing submissions at a time to be agreed on Wednesday.
Yes.
So that's how I'm viewing it. Okay. Both happy with that? So, time for resumption will we have any restrictions on the room then, or is that too far ahead for you to know whether there's anything?
I don't believe there are any, but we'll confirm that back in writing to the case officer and both.
Okay, so 2 o'clock, 1:30, either of those two. 2 o'clock, yeah? 2 o'clock on Monday the 4th of April. Everyone happy with that?
Yes.
When we've dealt with timetabling, might I just ask a question about closing speeches?
Yep. I think there's nothing more really I need to say about the timetable there. So what is it you want?
So it's only this. I like to keep them fairly short, and this case should be fairly short. When it comes to housing land supply, I've found inspectors and opponents take different approaches. I've tried in the past to shorten what I've got to say by using a schedule. And some people don't like that very much and insist that you read everything out, and others don't seem to mind at all. And I'm just wanting to float the point now, because what I'd rather not do is make submissions about individual sites that you'll have heard evidence on, and frankly probably won't be greatly assisted by my asserting one thing and somebody else asserting another. So to the extent you'd like us to address individual sites, do you have any objection to my seeking to do so through a schedule? I make that request to Mr. Banner as well, because I don't want to cause trouble when it comes to closings.
Well, I've no specific objection, Mr. Banner.
No, I mean, unless it's different people have different preferences. I'm personally not sure that it's very useful repeating every site-by-site point everyone's made. There's thematic points, cross-cutting points, but you may have a preference. What helps you?
Well, what will help me is making sure that each side's position is very clear
Yes.
from your closing submissions. And if the clearest way of getting that information over to me is via a schedule, then I'm quite content with that. What I don't want to do, again, stating the obvious, is leave the inquiry thinking, I wonder what they really meant by
Yes.
that. So, you know, I need to be totally clear.
I'm just wondering, so, and you may say, no, I don't want this, Mr. Banner might, but obviously we heard what both witnesses had got to say. That is already in the form of a schedule. Quite frankly, I'd much rather just deal with sites on a category-by-category basis in the way that Mr. Banner, I think, just alluded to, which is to simply say, in general terms, that's what I've got to say about this category of sites, and just move on and then refer to the schedule that you've got. Now, in order to make closings nice and short, does that sound like a helpful way of dealing with the matter?
I can't see a problem with that, but you know, until you've got to that stage, I don't know how clearly that will pan out in your own mind. But yes, I'm content with that.
There's one nuance, so which I'm sure you will have will occur to you too, which is because of the adjournment and the same evidence base essentially is being disputed on 5-year supply in this room. No, not in this room, online, virtually. Next week.
Yes.
In another it's conceivable, depends how quickly Howard Stevens gets onto it, but it's conceivable there might be a decision on the same evidence base by the time we come back. I think we just have to cross that bridge if and when we get to it.
Yes, yes.
In terms
I mean,
of what that
is the council having, are there 3 inquiries? Is that what I've understood?
yes.
Yes, yes.
There's Farley Fields, sir, which ends just before we resume.
Right, yes.
If anyone is going to have a decision before you start writing up, it's going to be next week's one, I imagine, because that's first, and the queuing will be done, you know, in about 4.5 weeks, I think, isn't it, before we come back? So just sort of, who knows?
Yes.
But
Just be aware
Howard
of that.
Stevens likes writing about 5-year land supply, so he might get onto it quickly. That may help bring the dispute between us to a focus by the time
Of
we
course,
get back.
yes, yes. We shall have to wait. Watch this space,
Indeed,
isn't it, that
yes.
one? Yes, okay. Okay, is there anything else? I was going to ask you for the attendance list back, but I see it's here. So that leads me to say, is there anyone out there who hasn't yet put their name on this? Right, so I'll have to pass this back out again. Anyone else? So I've got a feeling that I've got some red notes in my notebooks as to things that one side or the other might have said, would that help you, sir, if we handed it in? And I might have said yes, but I can't offhand remember what they are now. So obviously in this intervening period between now and when we resume, I'll revisit those, and if it's something straightforward that I was offered by one side or the other, I'll get the Inspectorate's case officer to write out, and hopefully that can be provided, and then if there's any discussion needed on it, we can do that when we resume.
Great.
But apart from that, I don't think I've got anything else to say. So anything from either side?
Nope, not from us.
No? Okay, well, thank you. On that note then, I shall adjourn the inquiry now. We'll resume at 2 o'clock in this room on Monday the 4th of April.
See you then.
Thank you.